Okay, we're back. Today, so if you look at what's happening today, almost where speech is concerned, almost nothing is illegal. Um, the only speech today that is considered illegal is to incite someone to take eminent illegal actions. That is about the only speech that is illegal, with the with the four additional exceptions. And these four forms of speech that we're going to examine now have never received constitutional protection, and it's unlikely that they ever will, because they just shouldn't. They shouldn't, and hopefully you'll see that as we go through. So there are the four forms: libel, obscenity, symbolic speech, and false advertising. So we will take a look at libel. Libel is a written statement that defames the character of another person. If that statement is verbal, it is slander. So it has never been legal to slander or to libel a person. An individual has their good name. That good name means something. It's like their property. It's the essence of who they are. So taking that away is really rights in conflict. Yes, you have the right to free speech, but it doesn't mean you can say whatever you want and take away the essence of who they are, take away their good name. That is a right in conflict. So to prove libel, you must show, the individual who is libeled must show that the statement is false. So the defendant, the person who's been accused of this libel, if they can show that the statement is true, that's an absolute defense. It is not enough. You can libel someone without it being libel. In other words, you can lie about somebody and not be held legally responsible for it if there's not harm that occurs. So there must be harm. If there's no harm, even though you've libeled them, you will not be held legally responsible, because that's the other part of the equation that must be there in order to prove libel. For a public figure, it's different. It's different. This idea of libel is different. Not only must the accuser prove that the statement is false and that it harmed that individual, but they must also show that the statement was made with reckless disregard for the truth or falsity of the statement, or with knowledge that the statement was false. That is the definition of actual malice. So the court has made it much more difficult for public figures, whether they are politicians or just people in the public eye, to prove libel. The idea here is an open discussion, particularly with politicians. You want people to be able to question them. This is the very essence of what democracy is. So you've got to show actual malice, that the statement was made with reckless disregard for its truth or its falsity, or with knowledge that it was false. If you cannot show that, even if the statement is false, even if the statement is false, but you had reason to believe it was true, then you cannot be found guilty of libeling a public figure, because we are trying to protect the freedom of speech. That's where the court has gone with that. All right, obscenity. Obscenity has always been deemed unprotected speech. Now, don't get confused between obscenity and pornography. Pornography, in today's view, is deemed as protected speech. Now, there's been some, it always hasn't been, there has always been a continuity with the terms being used to describe this. So obscenity today is speech that is not protected. Pornography is protected. In the past, sometimes they would use pornography and obscenity interchangeably. I'll try and point that out in point 3 when we get there. So obscenity has always been deemed unprotected. So there was three views going on here as to what is obscene, or what should happen if something is obscene. First was Hugo Black. He believed that the Constitution protected all speech, even obscene speech. Didn't matter. The First Amendment said what the First Amendment meant. It meant what it said, and it said what it meant. Congress shall make no law respecting speech. No law meant no law. That's what he believed. Another view was the Constitution offered no protection for obscene speech, but struggled to define what that obscene speech was. And a third view was Potter Stewart's view. He objected to what he called hardcore pornography. what we today would call hardcore pornography would be obscenity. But this is what he said. That he struggled to define what that obscene speech, or as he called it, hardcore pornography was. But he said, while I can't define it, I know it when I see it. I know it when I see it. You've heard the expression, a picture paints 1,000 words. Well, if a picture paints 1,000 words, how is it to describe what pictures are legal and what pictures are illegal? And so because of that, what happened was, for about a year and a half, the Supreme Court, this came at a time when the home video industry was taking off. Late 1960s, early 1970s. You had reel-to-reel at first, and then you had VHS tapes. And municipalities were bringing up some of these films, arguing that they were obscene and therefore unprotected speech, and they could prosecute those who manufactured, published them, and those who distributed them. And so the court, not being able to come up with a workable definition as to what was protected speech, what was merely pornographic as opposed to obscene, every Tuesday afternoon for about a year and a half would meet in a theater, in a theater viewing room. I believe it was. It may not have been in the Supreme Court. I'll have to look that back up. But they met in a theater in which they were shown films, and they were trying to decide whether they were obscene or merely pornographic. Now, I know this sounds comical and unbelievable, but you can look it up if you want, if you don't believe me. And after a year and a half, they got fed up with it and said, we've got to do something different. It was just a bizarre time. There was one judge, probably the most liberal judge of them all, a guy by the name of Justice Douglas. He's the guy that wrote Griswold versus Connecticut and created this court-created right to privacy. He never would go to any of them. Whether or not he'd already seen them all, that was another question. He even told one of his law clerks, he said, you go in my place, tell me if there's anything I can learn. Another judge was going blind at the time. He made his law clerks come and describe to them what they were seeing so he could judge. It was just a bizarre time. So finally, about a year and a half later, they came up with a test. In the meantime, they had issued 13 opinions to try and ferret out what was constitutionally protected speech, where this, quote, pornography, obscenity was concerned, and what was not. And so in a case with the name Miller, they created the Miller test. And they articulated these three standards that were really portions of what they had already articulated in previous cases, and now they're just trying to bring it into a workable whole. So they said these three things. To be obscene, one, the work taken as a whole must be judged by the average person applying contemporary community standards to appeal to the prurient interests in sex. Meaning the base, the debauched interest in sex. The average person, not some psycho, not some religious fanatic either, but the average person, and these contemporary community standards. In addition to that, it also needed, or to depict in patently offensive ways sexual conduct specifically defined by applicable state law. So in other words, look at this point too clearly. Patently offensive sexual conduct had to be specifically defined by applicable state law. In other words, it had to be in the state law that this conduct, this sex act was illegal. So what sex acts were illegal in the 1970s? Sodomy, among others, was illegal. So what is sodomy? Of course, sodomy is anal sex, but if you didn't know this, it's a lot more than that. It is also oral sex. So if sodomy is defined in a state law as being illegal, and then you have some film showing that, according to the Miller test, this could be obscene. And number three, and so with 1 and 2, it had to be 1 or 2. That big or. If it did this, or if it did this, it could do that. But it also had to lack serious, so it had to do one of these, and it had to do, point 3, it had to lack serious literary, artistic, or political or scientific value. So a lot of times what they would do, because after the Miller test, some of these pornographic films would have a discussion about literature or art or science to try and get around this, and then they'd go off and do their deed, because this became a giant loophole through which to shoot their obscene or pornographic movie from. That became the loophole, because they're saying this is just all about free speech, and that was just a guise. But that's what happened. All right, so next, speech, symbolic speech, has never been deemed protected. Here's the reason why. If symbolic speech was protected, you could do whatever you want and then argue that what you did was intended to convey a political message and therefore is constitutionally protected as speech. So you could murder somebody, you could rape somebody, and you could say, this is what the government has done to me, and make the argument this is protected under your First Amendment right of free speech, and therefore you can't be held legally responsible for that. Obviously, again, rights in conflict. You just can't go around raping and killing people to make a political statement. That's never was intended. So you can see the Supreme Court rightly denied this idea of symbolic speech. What about burning a draft card to protest the war? Should that be seen as symbolic speech? Well, if it's seen as symbolic speech, then it's unprotected. Should that be seen as just speech? That you are making a statement that you don't want to be drafted, and therefore that's what you're doing. Well, you remember rights in conflict is a big deal. Congress was given the right to conduct a draft. Draft cards are part of that equation in order to do that. Burning draft cards is a big deal. You cannot do that. That is not protected speech. All right. Burning the U.S. flag, is that symbolic speech and therefore should not be protected, or is it speech? The Supreme Court, so in the, I think it was the first Bush 41, passed a law, Congress passed a law, he signed it into effect, said you could not burn the American flag. So the Supreme Court later declared that unconstitutional. They said this was speech. So you might argue that this is an exception to that rule, that when people burn the American flag, they are merely expressing a view. Congress fought back, and they said, okay, that's, Supreme Court's had to say, we'll have our say now too. So if you burn an American flag, you'd better, particularly if you burn an American flag at a national park, you'd better do it in a fire pit, because if you don't, you'll be arrested for having an unlawful fire. But the reality is that's just a good law anyway. You shouldn't be going around burning anything outside of a fire pit in a national park or anywhere else, because we can all see what like the campfire did in Northern California. So there it is, speech. When we come back, we will pick up with our next civil liberty, crime, and due process.